Hello, I'm Adam Kielich, the principal attorney of the Kielich Law Firm in Bedford, Texas, in between Fort Worth and Dallas. Today's short video is discussing the charge of discrimination that must be filed with the EEOC or Texas Workforce Commission in an employment discrimination case. This charge of discrimination is an important part of the process of pursuing a claim of employment discrimination in almost all cases of employment discrimination that might be brought under federal or Texas law. This form is not particularly complex, but it is extremely important to the process, so it's important that people understand what it is and where it fits into that process. So the charge of discrimination is normally based upon what's called the EEOC Form 5, and it's a form that's been created by the Equal Employment Opportunity Commission, or EEOC, that has all of the information that the agency requires in order to begin an investigation of a complaint of employment discrimination. And the types of employment discrimination claims that the EEOC investigates includes age discrimination, for discrimination over the age of 40, sex discrimination, race discrimination, religious-based discrimination, disability discrimination, national origin discrimination, and discrimination by employers on the basis of certain types of genetic information. In these cases, the complainant, the employee, must file an administrative complaint. This is the charge of discrimination with the EEOC or Texas Workforce Commission. The one exception here is for sex-based pay discrimination claims. Because of the way that federal law is structured, it's not necessary to file a charge of discrimination to pursue these claims under federal law. However, for state law, you still need to file the charge of discrimination. The way that employment discrimination claims are broken up, there are both federal and state laws that prohibit these types of discrimination. For the federal law claims, these claims are regulated by the EEOC. At the state level, they're regulated by a particular branch of the Texas Workforce Commission, which is the Civil Rights Division. Both of them share some of the workflow. So if a charge of discrimination is filed with one, it's going to be cross-filed with the other agency. And both agencies will decide based upon their work-share agreement who's going to make an investigation and what involvement either agency will have within the claim. There are some differences under federal and state law regarding how these charges of discrimination are filed. Under federal law, you can file a charge of discrimination up to 300 days following whatever the event of discrimination was. But under state law, you've got to file that charge of discrimination with the Texas Workforce Commission within 180 days, or approximately 9 months for federal law, 6 months for state law. It's important to keep track of the actual days rather than the months, because with February being short 30 days and some of the months having 31 days, if you just count out the months, you can actually be a little over or under the actual 300 days or 180 days. It's important to file these charges of discrimination within the time period because the charge provides two functions within the process of pursuing a claim for employment discrimination. First of all, it triggers the agency to conduct an investigation with the employer. They'll certainly talk to the employee, get some information, but the investigation of the employer will unearth employment records. The agency can talk to management. They can investigate and talk to some of the employees. They're not always that diligent about investigating to that level, but they certainly can where they find the evidence warrants that use of their limited resources. More often than not, that investigation does not itself result in any particular result against the employer, but the agency can offer to mediate those claims between the employee and employer in cases where the EEOC or the Workforce Commission finds that there is probable cause of discrimination. They can choose to file suit and pursue those claims where the employer is unwilling to settle the claims based upon whatever terms have been proposed by the agency. The other important function that this charge of discrimination provides in the process of pursuing a claim is that the agency will eventually issue a notice of right to sue if they choose not to pursue the claims themselves, which is almost always the case. Now, this right to sue notice may include a probable cause that the agency found the likelihood of employment discrimination occurred, or the agency may have found no probable cause. That finding is not particularly important, but the letter itself is extremely important because it starts a new timeline in which a lawsuit must be filed to continue to preserve that claim and pursue it. And for a charge filed with the EEOC, its right to sue letter gives 90 days to file a suit. For the Texas Workforce Commission Civil Rights Division, that letter gives a 60-day time frame to file suit in state court. Over the past 10 years or so, the charge of discrimination has become an important part of litigating these types of employment discrimination claims. There was a time when the information put into the charge would be very minimal regarding the actual facts or explanation of the discrimination alleged by the employee. And employers and their attorneys went into court and argued that the information on the charge was insufficient to put them on notice of what the complaint or the claims of discrimination and provide a legitimate defense against them. The courts have agreed in many cases that more information is necessary. So it's important not only that the charge is filed, but that the charge is filed with sufficient information to be able to survive this, it's a motion to dismiss and be able to pursue those claims further into litigation. If a court finds that the information in the charge of discrimination is insufficient, that can stop those claims dead in their tracks, and that's it. So it's important that the charge is filed with sufficient information, and then when that right to sue notice is issued, that the party properly pursues litigation within the appropriate time period in the appropriate court. So again, these charges of discrimination apply to these particular types of employment discrimination. Additionally, I should add that retaliation claims based upon one of these types of discrimination will also be handled through the EEOC or Texas Workforce Commission, and a charge of discrimination is necessary in these types of retaliation claims. Now, there are other types of employment claims and other types of employment discrimination claims and retaliation claims that do not require this charge of discrimination. And these will include FMLA claims, wage-based claims, overtime claims, employee benefit claims under ERISA, discrimination on the basis of military service, in workers' compensation. There are all claims available under these types of laws. There are also retaliation claims available under these types of laws, but the EEOC and the Civil Rights Division at the state level are not involved, so a charge of discrimination is unnecessary. But if you do have a discrimination or a retaliation-based claim that falls under one of the types of discrimination discussed at the beginning of the video, it's important that you talk to an employment discrimination lawyer about your claims and about proceeding with this charge of discrimination to make sure that you protect your rights and protect access to the courts to seek relief for these discriminatory acts.